Good afternoon. Welcome to the second in a series of events organised by Amnesty International in conjunction with Professor Patricia Lundy of Ulster University. These events are part of information gathering in a co-design process as recently announced and initiated by the Northern Ireland Executive as of February 2021. This co-design process has context in the fact that scoping exercises that began in 2013 after the mother and baby, Magdalene laundry and workhouse institutional issues had been deliberately omitted from any previous state investigations, including the historical institutional abuse inquiry of 2012 to 2017. And so the Northern Ireland government decided that it would set up an interdepartmental working group to look into these institutional issues in 2016. As a result, in 2017, it was announced that an academic government commission piece of research would be carried out as part of, I suppose, a wider, more substantial scoping exercise with fairly limited, narrow terms of reference. And it eventually handed in its report to the executive in August of 2019. It took, unfortunately, until February 2021 for that, or 26th of January 2021 for that report to be published. And so on the back of that, the government announced then what would be a co-design process where victims and survivors would be given some sort of empowerment, as we've been told, in shaping and formulating how a future statutory investigation or some sort of ilk would be looking into all of the institutional abuse and crimes in question. So as part of that process then, three expert truth panel facilitators were appointed just recently to help victims and survivors shape that process and take those recommendations then to the government in the next 6 months, who will then take those recommendations on board, and hopefully then we will work together with them to initiate what would be a statutory investigation to look into all of the substantial issues. Part of this information gathering obviously would include a process where Amnesty and Professor Lundy have decided that it would be good to take into account the accounts and experiences of various people, victims and survivors, journalists, academics, etc., who have been involved and have knowledge of various inquiries and commissions that have been carried out across the world over different timescales. And to this effect, that's why these series of events have been set up. So without any further ado, I'd like to introduce the first speaker today. That would be Professor Kathleen Mahoney. Kathleen was the chief negotiator for the Assembly of First Nations for the Residential School Settlement Agreement, and also a major architect of Canada's Truth and Reconciliation Commission. Kathleen today will speak about the lessons from Canada's Truth Commission. So good afternoon, Kathleen. The floor is yours.
Good afternoon. Thank you so much. And before I start, I'd just like to thank the organizers of this, particularly Patrick Corrigan with Amnesty International and Patricia Lundy, both of whom I've worked with in the past, and they've done remarkable work in moving this issue forward in Ireland, and I'm very happy to participate today and hopefully add some of our experience here in Canada to your processes there. Yes, as Eamon has pointed out, I was the lead negotiator for the Assembly of First Nations, which is a politically representative group of First Nations in Canada, of which there's over 600. The TRC, it's important to note, was one part of a large holistic settlement agreement that was actually the largest class action settlement in Canadian history. And the parties to that agreement were the survivors on the one hand and the Government of Canada and several denominations of churches on the other. The Government of Canada was responsible for enacting the policy of an assimilative program in establishing residential schools to assimilate Indian children into white ways of living and thinking. And the churches acted as their agents in running the schools. And another thing to point out initially is that the settlement agreement contained many elements in addition to the Truth Commission. It compensated survivors for individual abuse, sexual, physical, psychological abuse. It compensated for loss of language and culture to all of the students that attended these residential schools. It included healing resources, commemoration funds for those who had passed on. It also provided for an archive and a research center to allow survivors, families, researchers, students, and so on to access the material gathered by the TRC. It established an education trust fund, intergenerational reparations, and all of this in addition to the Truth and Reconciliation Commission. So it was a very holistic approach to resolving the problem. So what the question, one of the questions I've been asked is, what worked well with the inquiry? What worked well with the TRC? And I think I can say quite confidently that by and large, the TRC in Canada worked very well. And one of the reasons for this was because it was informed in all of its activities by the principles developed in the exploratory dialogues by the Indigenous people themselves. Now, it has to be understood here that the survivors were one group of people affected by Indian residential schools, but the effects are very widespread in all of the communities. Everyone in the Indigenous community in Canada was touched in some very negative way by Indian residential schools. So it was very important for the TRC to have that understanding in its creation, in its processes, and in its purposes. So it's also important to understand that the principles that were articulated by the Indigenous peoples themselves reflected Indigenous customary law. And the customary law of Indigenous people, although it's not pan-Canadian, and there's not one law or set of laws that reflect Indigenous legal principles, nonetheless, there are some universalistic concepts that tend to cross all of the Indigenous communities in Canada, and they are accessibility, victim-centered, confidential, do no harm, protect the health and safety of participants, be representative of the community, be transparent, accountable, open and honorable, comprehensive, inclusive, educational, holistic, just and fair, respectful, voluntary, flexible, and forward-looking in terms of rebuilding and renewing Aboriginal relationships and the relationships between Aboriginal or Indigenous and non-Indigenous Canadians. Those were principles that can be gleaned out of Indigenous law and Indigenous legal principles. So in other words, the TRC's processes and goals were guided by survivors and their Indigenous customs and legal principles. So what this did was to help develop trust from the outset between the Truth and Reconciliation Commission and the survivors and their families and communities, because they could see their values and their customs and ceremonies and symbols reflected in the Commission's activities and processes. And this included witnessing ceremonies. It included a ceremonial, typically beautiful, carved Indigenous work of art that was a box that contained school artifacts. Recognition survivors who had passed away as very critical to Indigenous practices and legal principles. Celebrations of their language and culture at each national event. So that was another aspect. The TRC was not seen solely as a place to hear desperately sad and horrible stories. It was also seen as an opportunity to celebrate Indigenous culture. So some of the showcasing of the best of Indigenous culture was part of especially the national events, where there was dancing and ceremonial activities and art displays and so on and so forth that showed the rest of the country the richness of the Indigenous culture and the pride in their culture. There was also, feasts held and people came. Nobody was left hungry or without shelter. There was support provided for meals and accommodation and so on, so that the most people as possible could attend. Now, because the dialogues required that the commission be representative, survivors could see themselves reflected in the composition of the commission, its staff and its researchers. 2 of the 3 commissioners were Indigenous, one of them being a survivor who had spent 12 years in a residential school and suffered horrific abuse there, the other being a former judge of the Manitoba Queen's Bench Court with extensive experience in judicial inquiries into systemic discrimination against Indigenous peoples. The 3rd commissioner was a journalist whose husband was a residential school survivor. So in addition to the commissioners, the majority of the support staff for the commission were Indigenous professionals and others. Widespread media coverage by all of the national media, as well as the live streaming of commission events, worked well to educate the non-Indigenous public about residential schools. As I mentioned, residential schools were an unknown reality of history in Canada for over 150 years. So the education component was very, very important to get public support for which was to follow, which were the recommendations of the commission. One of the goals of the commission was to build momentum for subsequent events in other locations, so media support was critical. In fact, it gained widespread public support for the TRC as it progressed. The public participation, especially the non-Indigenous community, increased over time, such that at the end of the process in Vancouver and Ottawa, there was tens of thousands of people came out for marches in support of the TRC and its 94 calls to action. So a measure of success of those, other than those that I've already talked about, was reflected in the participation of survivors and other Indigenous and non-Indigenous people in the events and testimonies. Over the 6-year period that the TRC was active, there were 6,750 witnesses heard from across Canada in the national events, of which, as I said, there were 7, and there were 73 community events where the TRC and or representatives of the TRC went into individual communities, some very remote communities where it's very hard for people to travel out of. The TRC went there to those communities and heard from survivors. And so these community events added enormously to the data and testimonies that were recovered. There were 1,355 hours of recordings made of testimonies and tens of thousands of participants in the TRC events in the 7 major cities in Canada where the national events were held. The TRC's outreach to schools and universities across Canada worked very well, I think, as the national events were well advertised in educational institutions, and they were held in accessible locations where people could easily come to the event. Students of all ages participated in TRC activities and marches. And as I said earlier, they built over time as the TRC's activities progressed. I think another reason the TRC worked well in Canada was because the TRC was independent from government in all respects. The funding for the TRC, the $60 million it was provided, came from the settlement agreement itself, not from any kind of government funding. And the settlement agreement itself was judicially approved in all court jurisdictions across the country. So any non-compliance with the agreement by the government or the churches went before judges specifically assigned to deal with disputes arising under the settlement agreement. So these judges, there was 4 of them that were designated to be judges to deal with residential school matters, became very expert and knowledgeable about the settlement agreement and all of its aspects. And so that way of enforcing the agreement was quite effective, although there were wins and losses in the litigation over time. The TRC report worked well. It was very comprehensive. It's a 6-volume history of the residential schools and their consequences. It's available free online in English, French, and in, I believe it's 3 Indigenous languages. So it's very accessible. The 94 calls to action, which address all of the sources of systemic discrimination uncovered in the hearings, are being taken seriously. At the present time, 10 of the 94 calls to action have been completed, and 60 of the calls of action are making what has been called by evaluators moderate progress. So that's over 80% of the calls to action, which is quite remarkable because normally in Canada, the history of dealing with Indigenous matters tends to languish, and reports tend to gather dust on shelves in bureaucrats' offices. So this aspect of the Truth Commission has been embraced largely in public institutions like universities, the medical profession, the legal profession, social workers, and so on, are all modifying their practices, which have been shown to systemically, in many cases, discriminate against Indigenous peoples, and those are being corrected. For example, at my university, the University of Calgary, as well as in many other universities across the country, calls to action regarding education have resulted in indigenization, that's a new word, indigenization of our institution being adopted as a policy. This has resulted in changes to hiring practices for faculty and staff, which notoriously have omitted Indigenous participants. It's affected the recruitment of students, admissions policies, the availability of grants and scholarships to Indigenous students, and it also has resulted in curriculum changes. In my law school, we now teach, I teach in this area myself, Indigenous law and legal practices, Aboriginal law, which is somewhat different, and I won't go into that explanation right now, but we're in the process of looking for tenure track appointments to be made from the Indigenous community. And we have also advertised for a person to manage our indigenization at the faculty. So, that is happening across the country. Law societies as well. I know the law aspect of the 94 calls to action better than others, but law societies have to some extent embraced the recommendations in that they require now in their educational programs Indigenous input on cross-cultural awareness and residential school understandings. And there is an awareness now in Canada that more Indigenous judges must be appointed at all levels of courts. So I think when you look at those factors, it's quite easy to say that in large part, the TRC was successful. One other thing is that a research center has been established at the University of Manitoba, and it archives all of the, I believe, 20 million documents that have been accumulated over the period of time the Truth Commission was operational. And these have been digitized and are accessible to families, survivors, Indigenous communities, as well as researchers, students, and so on. They're protected, of course, by our quite strict privacy laws, and that has actually been litigated. But nonetheless, there is a huge repertoire of information that will be preserved forever in that archive. So those are my thoughts, and thank you very much for listening.
Okay, thanks very much, Kathleen. Thank you. Very comprehensive. If I could just now move on to our second speaker. This is Jerry McCann. Jerry is from the Rosetta Trust. He's a survivor campaigner for the previous HIA inquiry, which operated from 2012 to 2017. And Jerry is going to speak about survivors' experiences of that HIA and the lessons from that Northern Ireland HIA inquiry. Okay, welcome, Jerry.
Thank you, and thanks, Mr. Chairman. Could I just place on record to thank Patrick Corrigan of Amnesty International and Professor Lundy of Ulster University, and of course your good self for the invitation here. I hope by my participation will give some sort of guidance and ideas of where we went wrong and where we can put things right. First and foremost, I am a survivor. I went through this particular journey since 2009, obviously seeking an inquiry and then participating in the inquiry. And I feel my experience has, as an individual, has been traumatic, and for me, at times, it's been very, very difficult. But nevertheless, upon that, we, as chairman of a survivor group, Rosetta Trust, we represent some of the region of almost 300 survivors, although we like to think that we speak on behalf of all survivors, irrespective of those who have allegiance or don't have affiliation with groups, but nevertheless, we're all the same people who went down a particular journey that we'd rather not have went down on. So, to further ado in terms of that, I feel that the terms of reference in regard to the Historic Institution inquiry was not broad, it was very narrow in terms of the limitations of survivors to recall their experience or tell their experience was stated in such a way that they ignored the likes of the education impact that many of these survivors, from an academical point of view, were ill-equipped to move into society in later in life. The loss of opportunity being another factor, and ill-prepared for the world itself. So we feel, certainly I feel, there is lessons to be learned from that. But we had two components of the HIA inquiry. One was the acknowledgement forum, which meant that survivors could go and talk to two members of a panel in a very relaxed atmosphere in a sitting, like a sitting room with a cup of coffee or a glass of water, and able to relay your experience during your particular journey of being in an institution or institutions. From my perspective, I found that very rewarding, that I was able to unload what I was carrying for quite considerable time and lay dormant for quite considerable time, that I felt at long last somebody's going to listen to what I went through. And I no doubt many my fellow survivors may have felt something similar. Being in that environment, I was able to articulate my journey in such a way that I had control of it, that I wasn't steered or directed by an outside body. And then if we flip that side, you know, the fact that I spent maybe a couple of hours telling my story, I could have spent 2 or 3 days talking about it, but I felt the 2 hours was enough for me in terms that I got most of what I wanted to say off my chest. And the two people who engaged with me, and I don't mind saying Laura Gibbon and Tom Williams, which I felt, or Tom Shore, who I felt made me very, very comfortable. And that particular aspect of that HIA journey was for me probably the most important part of my involvement in the HIA. Then I volunteered to go to the statutory element, which was totally opposite to what the acknowledgement form was. The setting of the statutory inquiry was based on a courtroom, albeit a former courtroom. It had all the apparatus of a courtroom. It had barristers there. It had solicitors. It had public gallery. It had, obviously, Judge Sir Anthony Hart, along with his two colleagues on the top bench. And you could take them through your journey through a barrister, which I felt I was constrained that my real story didn't come out as what I would have envisaged or would wish to have had. So in all terms and purposes, we were steered, and it was a bad time for me because reliving that in a judicial process, which I never envisaged this would be the case, that obviously had an impact on me because I felt, to be quite honest, I was on trial. I had to take an oath, which I was happy to do. But I just left totally vulnerable, exposed in public gallery, exposed to the media. And, the old saying is when muck is thrown, muck sticks. I didn't envisage that was going to be the case. So from that point of view, I think the statutory inquiry, the scope of it was too narrow. It wasn't centred on survivors, where it might have been a fact-finding, detailed analysis of where there was systemic failings or systemic abuse, which the inquiry did clearly find out. That was the case. Unfortunately, it left survivors totally exposed of re-traumatizing, re-victimizing, and with the best intentions, I don't think that was the purpose of the inquiry. That the fact is that it was totally impersonal. There was no empathy, no understanding of the impact of what survivors had gone through. And like, I'm a man of 65, and I went to the inquiry in 2014, not once but twice, and I'm still reliving that. And yet, prior to the inquiry, I basically suppressed all my experience to bring up a family, to hold a job down, and to get on with life. And since then, I think through the focus of Rosetta Trust has helped me to reinvigorate myself and reinvent and be objective in terms of what I see was seriously flawed in an inquiry that should have been centred on survivors rather than dotting I's and crossing T's. Insofar as the inquiry itself, it had two elements in regard to the statutory. It had open sessions to the survivors who, as I said, were open to the public gallery, to the media, and we had closed sessions for the state and particular personnel. Now, this is meant to be transparent and open inquiry, and if anything, it wasn't, and that was seriously flawed. Why should survivors be exposed, who are the most vulnerable people in this process, were further exposed by the scope of the inquiry or the very narrative part of the inquiry that we were basically damaged goods, collateral damage in terms of how this inquiry was conducted. And this is no criticism of the chairperson, but I think the terms of reference and the scope of the inquiry should have been as such that if it was going to be open and transparent, it should have a process that's equal for everybody. And the most important component of this inquiry is survivors. From my perspective, that wasn't the case. So it's hard not to feel sore about this. I'm not bitter. I'm just sore and hurt that now that I'm 65, I'm going to have to carry this till I die. And while I remain strong as possible, I have to be quite honest, I've gone to counselling sessions, 12 sessions. I had to walk out. I just couldn't deal with it anymore. And try and focus myself on this support group, which has been a blessing for me. And I think through the help of Professor Lundy and Patrick and my other colleague John McCord from Northwest, they reinvigorated me to give me a focus to try and help survivors who were maybe more vulnerable than I was. And from that perspective, that's given me a purpose in life. To say what sort of lessons we can learn from the inquiry. I think the inquiry has to be centred on a design purely by survivors themselves. Because if we have a process where survivors are not even co-designed, then I think we become collateral damage. And I would be very mindful moving forward that any inquiry into migrant laundries and mothers and babies, I think you need to be very careful what you wish for. And I mean that with respect, because we are the victims, we are the survivors of that process and that journey. And if we are to learn lessons from the Heart Report, then it's quite clear that the model of the Heart is, in my opinion, was not a success. It's not a role model. It done a job, it done a purpose. But really, when you peel it all back, it actually left people more damaged than good. And I feel this is what we can learn from the HIA. So what can we learn from it? I feel that the scope of the inquiry must be broad. I think the terms of reference must also be broad in terms of what we want to go through this inquiry, what's it about, what aims, what's the objectives. And surely the objectives must be that it's a centred survivor inquiry in terms of how we can navigate these survivors through a process which is not harmonious, which is not difficult to go through or re-victimise or traumatise these survivors, because we have to be very mindful when we do an inquiry, there is going to be people who are going to be hurt, and not purely by intention but unintentionally. So I think by the scope and the shaping of this inquiry proposed has to be with the survivors involved, with their participation, and I hope maybe through my help and my journey that would give some insight to what is going to be out there for those survivors coming forward, that this is no easy ship to steer, that we have to navigate through very difficult waters, which at times can be very stormy. That I feel we can, as survivors, hold our head up high and say, hold on, there's an injustice done on us. We are the survivors. We want the perpetrators. We want these people or these establishments exposed for what they are. And there's no doubt about it, if you look through the history in Ireland alone, never mind globally, it's systemic over many generations. And the Scotland Inquiry Acknowledgement Forum, we're talking 73 years. You're probably talking hundreds of years where systemic abuse of children was very much rife throughout the island and the world as a whole. So in terms of having a legalistic approach, I think we're very much where we are with the redress. That's our problem. There's too many legal people involved in the redress aspect, and that in itself makes it very convoluted. That the language that the redress people are using, they question people's statements. This was to be a centred redress process for survivors, and unfortunately it's not. And therefore, I would like to think that whatever redress is formed, that it's the involvement of survivors and not be it civil service, like from the executive, who put out a public consultation for survivors to take part. And I know that some of the recommendations which were established by Professor Anthony Hart, that he put one caveat into this particular redress process, and it still resonates with me today. Be mindful of the public purse. For a chairman of an inquiry, an independent inquiry, should never have to influence a redress process in any shape or form. And I firmly believe, as many other survivors, that the chairperson actually stepped outside his remit and influenced the redress process. Well, that was seriously a mistake. And then through the consultation, and you can, when you look at it and see the legislation, it has the chairperson's personality, his design, his influence in a redress process, which sadly today survivors are being shortchanged. Because one of the recommendations in the consultation where survivors were very vociferous in opposing was a cap. The cap in the redress is £80,000, and the creative bands from 10,000 to a maximum of 80. To date, that 80 has very few people have hit that particular target, and we believe there should not be a cap, because you can't put price on abuse of systemic failings, systemic abuse, on people who were children, who are now adults, whose childhoods were lost, whose siblings were separated, who suffered all forms of abuse. And you can't put a price on it, but unfortunately, because there's a cap, there is a price. And that has caused more anger. It's not about the money, but the fact we've been labelled in brackets of what impact it had on us. I lost a childhood. I'd never seen my mother. I don't have any other family members. But I got on with life with all this baggage that I have and reinvented myself. Doesn't make me any better than anybody else. But I'm proud who I am. And I live each day that I would like to try and help somebody or help others who are less fortunate than myself. And to get this opportunity, to just articulate what my journey has been, and I hope lessons will be learned moving forward. And listening to Kathleen, I've worked with Kathleen and many seminars. There is a correlation with the Canadian schools and what they've went through to get justice, never mind redress. I don't believe we've got justice. I believe this is smoke and mirrors. I believe an inquiry vindicated us as victims. But when it came to the redress, they re-traumatized us. And so from that perspective, I hope what I've done here today has given insight in how we move forward. And I thank you, Mr. Chairman, for allowing me to give this opportunity to participate in this. Thank you very much.
Thank you very much, Jerry. That was a powerful contribution. I really appreciate that. Thanks now. If we could move on to the third speaker now, it's a Connell Luvarda. Connell was formerly a journalist with the Irish Examiner newspaper in the Republic of Ireland, and he's also a lecturer in NUI Galway. And Connell is going to speak on the lessons learned from Ireland's inquiries and redress schemes. Welcome, Connell. The floor is yours.
Firstly, I suppose just thanks for having me. Thanks for inviting me to speak. I know there's a lot of people here with certainly a greater expertise than me in this area, by virtue of, I suppose, their academic credentials or their lived experience in one of these institutions, or both. So like you said there, I mean, my main introduction to this issue is as a working journalist. So I spent about 10 or 11 years in the Irish Examiner. And in that time, the areas I really focused on, or certainly that I ended up accessing as a journalist, were essentially Ireland's treatment of unmarried women, and all of the practices that went with that. I suppose primarily forced and illegal adoption, infant trafficking, and falsification of identities and records, and that type of thing. Obviously, in Southern Ireland here, what led to that becoming a big issue was obviously the discovery of remains in the Tuam mother and baby home, and that brought the issue kind of into greater public knowledge, I suppose, from about 2014 on. But I suppose I was certainly writing about it from 2009, 2010. So I suppose it's from that perspective, and my interactions with commissions as a journalist rather than an academic or a survivor that I'm speaking to you now. And I suppose that's how I can view either the positives or the failings of the types of investigations we've done in the South and the way we do them. I suppose from the point of view of you're following the same line of investigation, certainly in the North, and from my perspective, I suppose the key to any of these inquiries is the focus of them, and that they're human rights focused, survivor centered. And I mean, I suppose that sounds like something obvious, but it's not something that has happened in the South. The experience of people interacting with many of the commissions of inquiries we've had has been that they have been quite adversarial, and people have found them, re-traumatizing. So I think that's really important to get right before you even start. And the other thing I think, and it's something I wrote about quite a lot, is that the focus is more on the issues rather than the institutions, if that makes sense. I think in Ireland we've tended to focus on set lists of institutions. So we're looking at the Magdalen laundries now, and it was obvious that we needed to look at the other institutions, and that we needed to look at the issues here, how we treated a cohort of women and their children, rather than we're looking at X number of Magdalen laundries now, and then we moved on to 14 mother and baby homes and a sample of county homes, but yet we left out adoption societies. So to me, that was a huge problem with this, because there was people left behind, and it had the impact of compartmentalizing the issue into kind of neat little boxes, rather than showing that this was a systemic problem. So I suppose the key failings that we made down here, I think, in reference to what the Mother and Baby Homes Commission, was that it operated largely in private, almost entirely in private, really, since its establishment in 2015. All of the evidence it gathered over a 6-year period was gathered in private. And as a result, I think there's been a pretty weak understanding of its in terms of transparency or the processes it used when it operated. I think any inquiry, it could be the best inquiry in the world, but if it operates in private, it's going to generate a large amount of distrust, but there's going to be very little understanding in terms of how it works. Obviously this has been hugely problematic in the South here, because the result of state inquiries that we have had into these issues and other similar issues is that upon completion, the records are usually sealed. So therefore you get one report and you get one narrative of how something happened. That's, while it can be questioned, it can't be questioned with access to any of the records. That's massively problematic. And I think it replays that whole concept of secrecy, which is where all of these issues grew from in the first place. I know the Clon Project down here, when it published its report, it outlined that a number of the survivors it spoke to were reluctant to give evidence to the Commission in any way, shape, or form due to the lack of clarity around how their evidence will be handled. That played out subsequent to the publication. There's been huge controversy around, the people who gave evidence to the Commission versus those who spoke to the confidential committee. Despite being, you were able to speak to either the Commission or the confidential committee, but people the Clonk report project certainly said that people were informing it that they were being directed to the confidential committee. And I mean, I know myself when I was writing about that aspect of the commission in 2015 when it was being set up, I'd asked a number of questions about how the confidential committee would operate, and was told that these queries, that they couldn't be answered because the committee, by its very nature, was confidential. Which again, it's not really a satisfactory answer, I think. And obviously, subsequent to the publication, it made a lot of headlines here. Was that the audio recordings of the 500 or 550 or so people who spoke to the committee were destroyed, and no transcripts of the conversations were kept. In contrast to that, a very, very small amount of people gave evidence to the investigating commission itself. And where those people did give evidence, there was a stenographer present. So, I mean, it's clear the problems that are emerging from that, where a large number of people are directed to one aspect of the commission. There's no recordings and no transcripts. People then obviously raised concerns that that their evidence wasn't treated, I suppose, in the same context that they had intended it in the confidential committee report. Now, subsequently, copies of those recordings have been found, and people are going to access them. But I mean, without the kind of huge amount of publicity that went behind that, I'm not sure that would have happened. So I think issues like that around transparency and how sections of inquiries work, particularly when they're interacting with survivors, I think need to be absolutely concrete before you start. You can't just be going into this process unclear of how your evidence is going to be gathered, how it's going to be treated in the final report. I think issues like that have to be nailed down early so that everybody goes in on a level playing field. The other problem here, and again, there's legal people more qualified than me to talk to it. The Commission of Investigations Act here, severely limits the possibility of any documentation that's been given to the Commission being used for any other purposes outside of the Commission. So it can't be used in criminal proceedings, subsequent criminal proceedings, for example. The Commission itself is exempt from freedom of information or personal data access requests. Again, compounding that idea of secrecy and lack of transparency and operating entirely in private. So, I mean, I think those are key lessons that you guys can learn from and take forward. The other thing I think that should be, access to files here has been a huge issue for people. You have no right to your birth certificate down here if you're adopted. You've no legal right to it. You've no legal right to any of the files held on you. Well, you do, but they're subject to other issues around third-party information. So it's very difficult to access records about your own birth history. So I think for you guys in the North, I mean, I think it's crucial that anybody going to speak to any inquiry or engage with any inquiry process, that you have access to all of the relevant files that the Commission has relating to your own case. So, I think it's unfair if a survivor speaks to an inquiry where the inquiry has more information on your experience in terms of documentation than you have. So I think, it's vital that access to records is front and center of any engagement with the state on these issues. I suppose the second key point, and probably an obvious one, is terms of reference. I mean, I think, again, and it was highlighted a lot here, certainly by me anyway, in the press, and by some of the campaigners and survivor groups, is that the terms of reference to begin with in the South were very limited. And that's a kind of a theme that runs through quite a number of the inquiries we've had here. The investigations in Ireland tend to focus on, like I said, institutions rather than the issue. So, for example, this one looked at 14 mother and baby homes and county homes. So it's excluded literally hundreds of other institutions, agencies, individuals, obviously private nursing homes that were operating. So the experience of thousands of women were excluded from the process, simply because under the terms of reference, they weren't included. So you could have a woman who was in a private nursing home, had her child taken from her, and illegally adopted, or the birth was illegally registered, and this was facilitated through a religious-run adoption agency. That woman could have experienced the exact same thing that a woman in a mother and baby home experienced, in terms of loss, lack of consent, all those areas. But yet, because that woman wasn't through one of the listed institutions, her experience is excluded. So, I mean, that's what I mean by, I think, focusing on the issue rather than the institution is important. And I think that was a key failing down here. Now, the argument in response to that is, you have these open-ended inquiries. But I mean, I think you're going to have that problem anyway, because if you're just focusing on set institutions, you're essentially examining the same issue over and over again. And I think one of the issues that jumped out from the Mother and Baby Homes report down here was that the conclusions on adoption practices were really not well received. The chapter on adoption itself was, I think, limited, largely based on narrative, a historical narrative, rather than actually getting to the bottom of any of the practices that were at play. So I think the inquiry should be focused on the experiences of the impacted people, rather than limiting it to institutional matters. And that goes in tandem, I think, with having survivor experiences front and center, and having their voices front and center of anything, and not being almost an addendum to an inquiry. And I suppose the last thing I'll probably touch on pretty quickly, and I suppose this is me speaking with my journalistic hat on, is I think how you mobilize is important. I certainly think engaging with the state on anything, you need to be able to fight fire with fire. You need to have more than just journalists on your side who will run a story. You need to be more than an activist, or a survivor. I think in your ranks, you need to be stocked with the same type of people that the state is, whether that's supporting lawyers and academics who can argue your case along with you. Because certainly the state is well stocked with an army, and its primary goal is to limit issues around redress, to limit state culpability. So I think you gain a better chance of gaining a foothold in the narrative, as it were, by having the same type of team in place that the state has, and being able to battle them on the same fronts. To my mind anyway, I think, issues around social justice are defined by the people who control the narrative, and the people who push the narrative are usually the state and the media. So I think, and the state and the media can often work hand in hand. So I think to gain impact there, you have to be as prepared as they are. And I think that was a key lesson from what happened down here. And the other thing that goes in hand with that is, I think one of the most instructive aspects of the Mother and Baby Homes Commission and the response to it was exactly that, the public response, which was visceral. And that jumped out at me, and I think it stood in contrast to maybe an angry but certainly a more muted response to the McAleese inquiry. I think the campaigning groups in the South this time around learned from previous inquiries and came armed with, a well-stocked team who were able to fight for their case, and push their counter arguments, whether it's the lived experience of survivors to, legal human rights based arguments. And I think they also simplified the issue, because it is a complex subject, and I think that can suit a state narrative in some regards. And I think they simplified the issue to access to records, and that, people who are through these institutions can't access basic information about their birth history. And I think that drew people in, and people were amazed at that in 2021, adopted people and natural parents are still second-class citizens here, and can't access the most simple information that the rest of us take for granted. And I think that certainly caught the public mood, and the reaction online and certainly on Twitter, outside of the traditional media, was absolutely massive. And I think it was a pretty quick U-turn on the narrative being pushed by the state from the first day to the second day even. So I think there's a lesson there for how you guys go forward, that I think mobilizing the right team around you and mobilizing public support are really, really important in terms of gaining a foothold in the narrative and in the conversation. So I think they're the kind of 3 or 4 main elements that I've taken from working in the journalism sector and engaging with commissions on that front. I mean, I mainly focused on the Mother and Baby Homes Commission, but I think you can go back to numerous commissions of inquiry in Ireland, or certainly the McAleese Commission before that. Again, problematic in terms of its findings, but also very problematic in terms of the redress schemes that were set up. But I suppose you can focus on what redress looks like when you get to that point. But I think those are the 3 or 4 main areas I think I took lessons from. So I hope that was instructive. I'm happy to speak to any questions anyone may have, but thanks for listening to me.
Okay, following on from those fantastic contributions from yourselves, if I could maybe try and elaborate on some of what has been discussed here. I suppose that the common thread that runs through all of the previous inquiries and commissions is about victim survivor empowerment. There be common threads there of what is justice, what the victims and survivors want, on their priorities in terms of the variant justices of restoration, restorative justice, transitional justice, retributive justice, criminal justice, etc., etc. And both of your experiences with the inquiries that you were involved in, could you just give us an insight as to maybe what the feelings were of the victims and survivors post-process in terms of, on what even was the scope in terms of the criminal prosecutions and the process that were set up to try and receive some sort of criminal justice?
Yeah, yes, I could take up on it. In terms of post-inquiry, I have to say, not just me, but many of my fellow survivors were incensed and enraged with the statutory inquiry, particularly the acknowledgement form, I think, went relatively unscathed because it was a more relaxed environment, and the fact that the driver or the survivor could steer that in the way he or she wanted. But the collateral damage in regard to the inquiry is living with each individual survivor today. And that's been exacerbated now that the redress is up and running, where that's continuing on, where the trauma and re-victimisation is still continuing. And that's a sad reflection on inquiry that should have been there to support the survivor rather than re-traumatising them. And what lessons do we learn from that? We have to navigate through people who are very vulnerable, even though they're now in their formative years, that they're still carrying this burden which they thought they had unloaded in the statutory inquiry, particularly, and they have to live with that. And I'm obviously a living proof of that. So I would like to think from what lessons we can learn is that the inquiry should have a broader scope in how we take these people through this final phase in terms of the inquiry and where they are, not re-traumatised. And it's already been offered counselling sessions. That doesn't go halfway there. They need to be mindful that when they are taking survivors through an inquiry, the vulnerability and what damage are we doing by having an inquiry. And that's why I think shaping an inquiry for survivors moving forward would have to be designed by survivors themselves. You don't want a courtroom. You don't want all the like barristers and all these the legal fraternity getting involved and taking you through your journey. I think you need expertise, academics who are from a social background, welfare health background, and all that, and that would be more beneficial.
Jerry, can I just ask you, were the survivors who came forward to either the acknowledgement forum or the statutory inquiry, were they given the opportunity to be escorted in to give their testimony with a family relative, legal representation, or anyone at all?
Yeah, well, if you went through the study, you could bring a family or a friend, or they also would put a support person beside you, which I don't think anybody availed to that support person. It was probably more of a family member or a very close friend. But that didn't particularly put you at ease because you had the court theme, you had the judge, you had the barristers, you had the public gallery. So those safeguards weren't really there because the image that you had was a court. So I might as well be down to Chester Street in the law courts and go through that process because that's exactly what it was. And I think a venue for such an inquiry should not have a courtroom theme as its backdrop. It should have a more inclusive environment where it's not adversarial, where it's not accusatorial, where it is centered on survivors, how we take that person through that journey without being over exposing the survivor to the extent that the survivor is re-traumatized.
Obviously, when people go forward to counselling, one of the primary functions of that counselling would be, to facilitate people in an extremely safe, secure, and comfortable environment. So certainly going into an environment where everything appears so judicial and adversarial, as you say, is completely to the detriment of the person and potentially to the testimony that they're going to give as well.
It certainly does, because at the end of the day, when you're in a public arena, and irrespective of who's in the public gallery, the questions that may be posed to you could leave a certain amount of doubt or an element of somebody's been accused of something or somebody has pointed a finger at somebody, and that name is in the public gallery. It may be redacted in the documentation, but the fact it's in the public gallery, okay, it's not in terms written out by the media or on TV, but the fact that the Joe public can go to the public gallery, or anybody can go to the public gallery, even the perpetrators can go in the public gallery, and I found that very uncomfortable. So I think the concept of any inquiry must take those into consideration and make this process as minimal accessible to survivors with all that trauma.
Yeah. Obviously, the full purpose, the whole remit of all of this process for all of the victim survivors, all of the people affected, should be to do no harm and to do no further harm, and to take that into account. And when you take that premise, obviously, there should be a position of empowerment where every victim and survivor has a meaningful stake in the process, and that obviously necessitates, as yourself and Kathleen have already pointed out, the fact that there obviously needs to be a consultative and participatory role in every part, every mechanism, every measure, every part of that co-design process, to enable the victims and survivors to have that believability, to have that credence, and to be given that elevation, to mean that you're actually a major part of this process, and we are here to address all of your demands and your needs. Is there any aspects of your contribution that you would like to elaborate on and potentially inform us in best interest as we move forward in our own process here? What would be your key sort of points of advice?
Well, I think the key thing is listening to the survivors and creating a process to solve the problem, as opposed to imposing a process to come to a conclusion. I think that what we're learning more and more, especially from Indigenous peoples is that, problems are multifaceted, and they affect a lot of people, not just a small group of survivors, if you want to use that terminology, or the direct victims of an abuse. That abuse spreads to the connections that person has with family, with community, and all of that. And so you have to create a process that will solve the problem, not the other way around. I think that was the biggest takeaway from what we learned. And plus the other one was, of course, which is related, is that legal processes are narrow. They were invented to solve a problem in a certain way that gives a comfort zone, to lawyers and judges and so on, that is very difficult to adjust or to penetrate. And so overabundance of lawyers in these processes tend to drive them in a certain direction that is contrary to the way in which a complex and nuanced problem has to be dealt with. So I think that's the main takeaway. And of course, what comes with that is what Jerry was talking about, even the physical setting, which can be very alienating to people, the hierarchical setting of the judge up on a bench and the barristers and the gallery and all of those things. We never started any of our processes unless we're in a circle where everyone is equal and everyone has an equal voice to be heard. There was no artificial or hierarchical system overlaid, on the proceedings.
Well, I think the cross-border aspect of the issue around mother and baby homes is hugely important. And you can't examine what happened in the north without reference to what happened in the south, and vice versa. And I think access to records that were gathered here for our commission for use in terms of the inquiry in the north will be vital. How that's going to look in practice, I think, is going to be really interesting. When you look at how things have happened down here, the entire discussion has been around access to records and records being sealed. And, once a commission finishes, records being closed down. So I think in terms of the commission in the north accessing the commission of inquiry here, the records that they gathered, is going to require a little bit of finessing, I think. And that's going to be really interesting. I think what's encouraging in a sense is that I know that the people that have been tasked with setting out maybe what the inquiry should look like, I think the makeup of that is really positive for you guys. Maeve O'Rourke, I know, was involved, and I'd know Maeve really well. And Maeve was one of the most vocal critics of the inquiry model down here and how it needs to change. So I think those issues around access to records will be front and center of her mind, most definitely. So I think that's a really encouraging thing. But I think there is no way you guys can do a full and complete inquiry down there without referencing how that cross-border movement operated and with access to the same records. It can't happen without that level of interaction and cooperation, I think.
Listen, I'd like to thank everybody involved. We've unfortunately run out of time. If I could again give our thanks to Amnesty and Professor Lundy for their involvement in setting up the process. Again, we'd like to give our absolute massive thanks to Jerry McCann from Rosetta, victim survivor of the HAA, Kathleen Mahoney, and Connell for all of your contributions today. There's no doubt that these are very, very meaningful and productive discussions. We will certainly, as an activist, adoptee and campaigner myself, I could see great productivity in taking part in these discussions, and certainly we can learn a lot from them. So thanks very much, and again, take care of yourselves, and I hope to speak to you all soon. Thank you.